Muchas gracias y buenas tardes a todos los que
Thank
siguen
you
la
very much, and good
transmisión de este
afternoon, all
segundo
of
foro
you who are following
internacional, la
the
innovación
third
en la
day of
justicia.
the second international forum on
Continuamos con
justice
nuestro
innovation.
siguiente
We will
panel,
continue now with our
competencias
next
de
panel,
personas operadoras para una justicia de calidad.
competencies and skills of the
Modera
operating people for
Eduardo
quality
Martínez
justice. We will
Altamirano,
have as moderator
coordinador
Eduardo Martin
estatal de
Altamirano, which is a
Conjusticia
state
en el
coordinator
estado de
of
San Luis
Justicia in the
Potosí.
federal Mexican state of San Luis
Participan
Potosí.
Lila
We will
Zaire
have
Flores de la
Lila
CEA,
Zaira Flores of the
Javier Martín
CEEAD,
Reyes de
Javier
la División de
Martin
Estudios Jurídicos
Reyes
del
of
CIDE
the Judicial
y
Studies
Luis Eliud Tapia
Division of
Olivares, abogado
CIDE, and
defensor de
Luis
derechos
Eliud
humanos.
Olivares, who is
Dejo
a
la
human
palabra
rights
a Eduardo
attorney. I give the
Martínez.
floor now
Muchas
to
gracias.
Eduardo Martinez. Thank you very much. Good afternoon, everyone. On behalf of Mexico, Evalua, thank you for being with us in the development for this panel called Competence and Skills of the Operating People of the quality criminal justice system, the change that the criminal justice has undergone from 2008 up to now. It has created a need for the operators to acquire new knowledge. And this knowledge quite surely have transformed and acquired different and new characteristics with regards to the institution that is involved in the long and sometimes tortuous process of justice administration in our country. Without a doubt, these have acquired new roles, and this also is determined by the regulatory framework for which the operators have been trained. And we should add to all of this the changes imposed by new technologies that while they have helped the criminal justice system significantly, it's also a reality that our operators need to know further these technological tools to operate with a greater efficiency with regards to their daily activities. We start from the next questions. We will start the development of new competences understood as that performance, which is the result of knowledge, attitude, skills of a person in a specific context to solve disputes that appear in different fields of their lives. And in this case, specific case of the context of achieving quality justice, this is something that we need to answer through this panel. If we need a constant training through new mechanisms, new tools to face a new criminal justice activity with quality. Another important issue here is the advances and interesting proposals exist around our certification of our operators. What can we say, or what's the perspective about the use of AI in this case and the automation of some processes? This is another issue that we will try to answer here. These are just some of the topics that will be addressed by our panelists today. And with no further ado, I will give the floor, first of all, to Dr. Lila Zaire Flores, Certification Coordinator and Professionalization of the Center of Studies on the Teaching of Law, CAD, to share her opinions with us about all of these topics. It's a pleasure for me to meet you again, Lila, and I want to thank the CEAT with which I had the opportunity to collaborate for more than a year. We are great friends and great professionals. The floor is yours, Lila. Thank you very much, Eduardo. Thank you to all the Mexico Evalua team. It's a pleasure to be with you today and to share this table with people that I admire a lot. I'll try to organize my ideas, and maybe I'm going to do completely the opposite, but I'll try to order them. When I receive the document and the technical card for this table, I think that was the last topic you were covering, AI, whether there was any risk of displacement. And first of all, the topic on which I will focus is that of certification. But I'll try to answer this from what I believe. And I think there is no displacement risk, at least not in the short term. I was thinking about when I was saying this question, not just in the interactions that a person has with the justice system, but the interactions we have in our daily lives. And I was thinking about what happens when we want to when we have a problem with a credit card, an online purchase, an application, and you want to you want to talk to customer service, and you have a problem, and you send from one menu to another menu to another menu, and you find no answers because you just wanted to click star, 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 and get a person to listen to your problem and to offer a solution for you. And I think when we move this to the justice system, in which we have people with problems or who are subject or victims of crime, or they are being accused, they want to find at their institutions someone who will listen to them and to their problem and to offer them the different solutions for thereof. So while there are processes that can be streamlined to reduce costs, times, discretional margins, and to have certainty for the institutional answer. So there will be many other more complex ones that at this time we would not be able to solve, especially when at our institutions we have greater problems when we think about technological equipment and infrastructure matters. So there are institutions who have got no internet or have no computer equipment that does not allow them to have the interaction that we're having right now through Zoom, because they do not have microphones, because they have got no cameras. Well, it's going to be very difficult to think about other technological tools. And there is an important challenge here. And something you were mentioning, Eduardo, at the beginning, is the relevance of the development of skills for operators in the use of information technologies, and not just for their work, but also for training matters. And in our case, what we have been doing from the CEE, where we have a remote skills assessment through technological platforms, we have found some of the problems that people are faced with in the use of the platforms themselves, but also with regards to the other challenges that I was just mentioning before, which have a relation to the infrastructure and these people's equipment. Without a doubt, technology is offering opportunities here, and especially today with regards to training purposes and assessment purposes that we are working on. Virtuality has allowed us to reach more people, streamline and while streamlining resources. I think that those of us who work in the teaching field, this new way in which we this new teaching mode brought about by the pandemic, we can see what the platforms allow us to have non-synchronous classes. Maybe people can better administer their time now. And now also we have the possibility for the operators to go to those trainings, because they are not going to be distracted from the hearing time, the time that they have to devote to assisting people and problems that they have in their daily work. And sometimes this is going to prevent them from attending to training courses, like it's the case for other people. And sometimes the people who get more training are the people who are the least at the front line, because these are people who could be take some distance of, because they can take some free time of the daily activities to attend these courses. And in terms of skills and required for operators, if we start to think about what those skills are today, and we ask ourselves this, we will start saying many areas of knowledge, skills, attitude, as attributes that we identify as necessary as operators according to our own experiences, and that we see as a need. And quite surely we are going to find a common grounds and common skills, and we will all understand that these are necessary to operate a good justice system, or that any attorney needs. Establishing these competencies, I think this is the first step. We have to build the competencies profiles, because in the end they become the benchmark or the cornerstone upon which we're going to be developing training programs, and how programs for staff selection are going to be working later on. And when we are speaking about processes and the definition of competences, the first thing we have to do is to work on those profiles per skills that are required for each and every of the judicial profiles and skills, because even if we have some common ground between the judges, the public prosecutors, public defenders, that there are specific skills that they require with regard in relation to their own role. So that profile cannot be only be made unilaterally, or bringing a group of experts together just to define that. But this has to be group work, because the profile has not only a descriptive end in terms of the skills and competences that a person needs, but this is technical work that requires of an accompaniment of professional, not just of a specific area, not just attorneys defining what we need to know to do, without an accompaniment of education experts, psychometry experts that will help us to define the competences, the performance standards, and the indicators that can be observed and that can be measured and assessed. Because in the end, if these profiles and these profiles are going to establish the selection criteria or the performance assessment or training criteria, they have to be built in such a way that I'm sorry, I apologize for the noise in my room. I don't know if you can hear it, but there is a terrible sound for me. I'm sorry, I apologize for that. But that criteria that will allow us to measure and to be assessed.
the amount of people from different countries that are involved in this event. And well, I wanted to say 5 points, but I think I will have time for only 3. And I want to establish where I am talking from. I worked for a little bit over 8 years in the Center for Human Rights in Centro Pro, representing victims for the violations of human rights, victims of crimes and accused also, but also victims of crimes. For instance, the crime of torture. And after leaving Centro Pro, I have worked on the training for the operators of this justice system, especially from the judiciary at a national level, and also the general attorney's office in the country. And that's where my background comes from. And to try and answer some of the questions, I would like to say 3 things. I think I have enough time for that. First of all, is about centrality of people and their rights. And I think that's an element that may seem obvious, but I think it's always necessary to put it on the table so that we discuss these topics. Access to justice makes sense only when it is about thinking of people regarding their rights, not only as if they are the users of the system. In this regard, the human rights perspective in the job of any person that is an operator in the justice system, whether they are a district attorney or the public defender or a judge, it does not mean that this perspective of human rights does not mean that it should be deficient. In a certain moment, I think that based on the reforms for human rights and the writ of amparo, we confuse the use of principles of interpretation as a person or a way of doing the basic process rules. This wrong interpretation had negative effects against the approach of human rights that characterized it as inefficient. If they don't want to comply with a process term, they mention the pro persona principle. And I think that we need this from the defense of the human rights. And I think this also has a certain part, because access to justice is complex, it's expensive, and it's difficult. And the reform would do the possibility of having access to justice in a proper way. I will close this part by saying that the approach of human beings for the operators of the justice system should be for the human rights, which doesn't mean that it should not be inaccessible or something that no one can understand. And there is a second point that has also had a lot of debates in the public space and social media. But beyond these rulings that are easy to read, we need to talk about the democratization of the judicial areas. I think we have the ethical responsibility of telling people this in a simple language, and also the translation of judicial technicalities to some people, because sometimes some of the operators of the justice system are reluctant to it. And I would like to give you an example that I saw working in the Pro Center. We did a report with a group of people from Universidad Iberoamericana, and we did a study on migrant women that were victims of crimes in Tapachula. And we visited them in prison. This was a woman, she spoke Mayan, and she had been there because she was accused of human trafficking. She didn't really know Spanish, and that's why we tried to communicate with that, or at least that's what we thought. In the conversations we had with her, she told us how she was forced to sign documents in the presence of an interpreter, and she didn't know how to read or write. And after 2 visits with the intervention of the university, we got a Guatemalan interpreter who spoke her language. And that day we discovered that she was happy, but she was happy because of what we did, but she was also mad because we didn't set her free. She didn't really know who we were. When she realized who we were, she changed her position in front of the group, and that allowed us to have a better intervention, to get to know what was happening and have a better option in her process and change the final decision. This is related to the language barriers, but this is also applicable for people who speak Spanish but do not understand the legal language. And when we talk about people who are understanding the terms of the process, sometimes they don't even know what is happening. Their expression changes, and that has an impact in their perception of the justice system, but also puts them as what they are as part of this process. And as I was saying, the responsibility to communicate the complex legal language or legal terms for all people is just in the hands of lawyers. Something that I don't want to oversee here in the committee of against forced disappearance in the country. Mexico is part of this committee. And it's not just casually. There are thousands of people that are disappeared and that are forced to disappear by the government. And what I want to say is that for the judiciary, the reality that the disappearance of people has opened new conflicts against the judicial assistance that was not contemplated. And I put an example of the declaration of absence. And this has changed the way in which civil law has approached the new legal frameworks, a new interpretation that is being built. And I think it is necessary to train all the operators from the justice system in the topics that involve the definition of the judicial matters that are involved in this forced disappearance. I think that I ran out of time. I can stop now and I can continue later to close these ideas. Well, we can stop for now and then we can continue with you, Luis. What you're mentioning is very important about the democratization of the legal language so that the whole citizenship can understand it. Right now, I'm going to give the floor to our colleague, Professor Javier Martín Reyes. Thank you very much for the invitation. It is a great pleasure for me to be in an event by Mexico Evalúa. We all know that this is an organization that has been at the front of many topics, not only for the specific topic that called us to this table, but I think that good part of the transformations of the justice system, specifically the criminal justice system that we have seen in Mexico, they have been addressed, studied, and analyzed from Mexico Evalúa. And I think that it is a great pleasure for me. Thank you very much to Cristel Rosales for the invitation to this event. I think that this is an amazing space to have a conversation. I am very glad to be here with people that I care for and that I respect. Some people such as Lila and other people that I don't know, such as Luis or you, Eduardo. And I am going to start because I know we have a very short time. And I want to set also the background for you to know where I am talking from. And the reform from 2008 created the need to have new tools and new knowledge for the operators of the criminal justice system. But I would like to address this in a more general way. I have the idea, and I agree with Luis, that not only the 2008 reform regarding criminal justice, but also the reforms of human rights and amparos in 2011, I think that many of the deficiencies that we had in the training and in the practice of the judicial operators, I think that these deficiencies are the main obstacle that we have so that we can do more interesting things, such as the use of new technologies, or as it would be the incorporation of artificial intelligence tools as it was established earlier. And I'm talking about other experiences that are very personal, but I think that they have something to do with how law is applied in Mexico currently. I worked in the judiciary for almost 5 years. I was also in the election court and also in a regional area in Monterrey. I got to know the amazing work that the CEA does in these judicial matters, and I had the responsibility of coordinating a work group from one of the justices in that area. And something that we were able to do is part of the work group from the previous justice, who had great experience and great knowledge. These were people that were 40 or 50 years of age, and they had been working in this electoral justice system for more than a decade. And these were people that were doing their work in a very good way. But I think it was also very obvious, since we started drafting the first bills in that room, that there were a lot of deficiencies. And I will set a couple of specific examples. I remember that we got a case, we took that to one of the collaborators, and then we got, after 5 days, we didn't have anything, and then after 2 weeks, we didn't have anything. And in electoral matters, the times are very short, and we need to do that as fast as possible. And after talking to her, she told us that she was struggling because this complaint had a problem on a regulation that was being contested. And this seemed to be a relatively easy case for us, because we had people that were in the Supreme Court, and we knew that this specific type of regulations in other states were based on the Constitution. And she told us that she had never done a study like this in the more than 15 years that she had been in this system. And this court, since 1996, has these cases of constitutionality. But this is something very basic that we should see in a class regarding the theories of law, and she didn't have that. And I also was able to work with a very good lawyer, and what he had, I don't want to mention his name, but he had something that was only a collection of pre-created paragraphs, and these were dozens of pages, and he copied and pasted the paragraph that he thought that was the best option to answer for the concepts that were established in that plan. Once again, this is an idea, and he said, well, these are the criteria. So I have these other criterias, and I'm just accommodating it according to what I believe. And that's the idea he had on how this was done. And this was the second personal experience that I wanted to share. For 4 years, I have been a full-time researcher professor in CIDE. For 3 years, I had the opportunity to coordinate this law program. And I think that many of the solutions to the problems that we have right now with judicial operators, and that are the foundation that allows us to do more interesting things is within the education that we have. I think that continued education is very important in specialties, master's degrees, postgraduates are very important. But if we do not solve fundamental problems with educations from the root of the degree, we are going to have problems. So since CIDE started and was born in 2001, it was open as a anti-formal program. And by that, I mean that we think of three things. The first thing is to understand that law is not a static phenomenon. It's a dynamic phenomenon. And with this, what we mean specifically is that learning about law is not only about memorizing a group of regulations and concepts, but we need to see law in action. The blog of CIDE is called like that because what these judicial operators are doing, or what is being done in the specific areas. We cannot learn criminal law just by reading the Constitution or the National Code of Criminal Procedures and the local codes. We need to see what the practices of the operators are. And also, I think that from CIDE, we have always tried to understand, or we have defended the idea that law is not only an abstract group of regulations that are not related to reality. There is a factual reality that we need to understand, and that's why we need to give the operator some minimum foundations of interdisciplinary knowledge. And in constitutional law, students at least need to find something about political sciences. If they need to understand something about economy for them to understand the market that they are trying to regulate through these regulations. If they want to do criminal law, they need to know about criminology, sociology, something about empirical studies. And the third thing, and I will close with that because I know that I'm running out of time, I think that in CIDE and in other places, and here I'm speaking from my personal experience, and I know that there are a lot of institutions that are also doing these things. The third point that is very important for me from this experience is understanding that lawyers cannot be experts in everything. I always give the example of an idea that was already overcome, fortunately, is this old study plan that existed in the 90s. It was around 10 semesters with 8 subjects each semester, and in the end, lawyers ended up studying 80 subjects of only law. From the first semester, we only studied the regulations, and that's it. I always give that example, but in that study plan, one of the mandatory subjects was agricultural law. And I don't say that this is not important, but it should not be a mandatory subject for everyone. I think that criminal law is a very good example as well, but we need to bet on lawyers that have a very robust and strong foundation of knowledge, that know about philosophy of law, that know about procedural law, constitutional law, and all types of law. And after that, then optional subjects in which the students are able to learn by themselves. Because what we are seeing, and a great part of the challenges that we are seeing in the operation of the criminal justice system, is the difficulty of the people that were trained not only with an old paradigm, but also people that were not taught to learn by themselves and adapt to the new realities. There is this idea of thinking that law is something static, that there are concepts that cannot move, that come from Rome and can never be modified, not even by the legislator, nor by the reality. And well, those were my examples. I will leave it there. And I'm sorry because I know I took a couple of extra minutes. Don't worry. Thank you very much, Javier, for your presentation and for sharing your knowledge with us. I wanted to ask I would like to tell the 3 speakers, I am told that we are running out of time. Each of you will have around 4 minutes to answer 2 general questions. And if we have a bit more time, we might be answering the questions that we have from the people who are participating in this panel. Now, the first trigger question that I would like to give you is, what is the relationship between technology and the system, the justice system workers? I think that there is a risk of displacement. I think that is a very general question that I am presenting. And also, what is the way to ensure the good performance of the operators of justice? Should there be a constant certification? Maybe Lila, you can talk about it. Well, I'm going to speak the first one because I think that I gave my opinion at the beginning of the conversation. I gave my example to customer service. And now regarding the training or constant education, continued education, I'm going to take 2 of the ideas that my colleagues mentioned. And one of them is access to justice and how competencies or the professionalism of those who operate the system, it can become a barrier, an obstacle to access to justice. And we need to face this responsibility of those who are intervening in the training of lawyers to guarantee that they have the competencies that the society requires when they are facing a problem that requires a lawyer, and the interaction with the justice system. Because in the last few years and the reports that we have obtained regarding the experience of the users of the justice system, we see that despite the amount of lawyers that we have in Mexico City, the needs are not being met. And also regarding the judicial education that Javier was mentioning, I think I can only agree, because many of the issues that we see in the operation of the system are a reflection of what happens in the classrooms and in the education, which we are reproducing constantly. And that's why it's also important to reproduce profiles. We have a profile per competencies, because if we define what we are expecting from a lawyer who is a judge, and what do we expect from a person that just graduated, we need to see the experiences that they have had since the moment they entered the major, and what are the competencies of the university when training them with the people that just graduated, and the competencies that they are going to develop during their professional life so that they can comply with the things that they are expected. So I think that we need to establish the definitions of what we expect from them and then talk about the profiles. And starting from that, maybe we can start working with what we are doing with the certification processes of professional competencies according to the judicial competencies. It's not just a general certification or training. We could do that because there are competencies that are common of all graduates, but how important it is to establish rigorous processes of assessment for people in general. I mean, judges, defenders, etc. And I think that's my reflection because we are running out of time. Thank you very much. Thank you very much, Lila. Now, Luis, please. Thank you. I think that I can connect my comment with Lila so that I can answer the trigger questions regarding the cases of disappearance. What I was saying is that due to the forced disappearance situation that we have in the country, the operators, and in this case, I'm talking specifically about the judiciaries and the operators of the justice system, require competencies that they did not have. They didn't know about the use of technology for the search of disappeared people. So right now, the control courts need to solve or decide on topics related to the search. If a general attorney denies a search or refuses to use a certain type of technology, the family of the disappeared person will go to a resource in court to request the use of technology. These people need to have the competencies to know that we have these type of photographies, that there are your radars, drones, and also to know about forensics and topics that were not in their ideas before the situation. And I think that this agrees with what Lila mentioned, because not all operators in the justice system require this, just a few of them. So we need to choose the training that is appropriate for the person that is going to use it eventually. Maybe a control court in a specific matter that is the one who is going to talk about it, especially, for instance, or the writs of amparo that are going to be used by some cases. Not only a certain specific amount of courts are going to use this type of amparos, and they are not all going to have the ability to get this training. And something that I think is very important, and I think that Mexico Evalúa mentioned it very well, is that we need to talk about the judiciaries, because sometimes we talk about these at a local level and sometimes at a federal level. And we say that all trials end at the federal level. And I think that they should all end up in the federal level, but they don't. Most of them end in the first part, and just only of them reach the second part. And being able to see the judiciaries that are solving most of the cases, I have been seeing statistics in Mexico City in civil matters and in family matters, and more than 85% of the cases in the last 5 years were solved in the first institution or in the second institution. And none of them, of the others, went to Amparo, and these first institutions are the ones that are deciding. So I think it's important to see the courts of the different states for them to acquire all these competencies in relevant cases, such as the ones that we are mentioning. I would leave my presentation here. Thank you very much, Luis. And please, Javier. Well, just quickly regarding the first question, if there is a risk of displacement, I think that I agree with Lila. I think that the lawyers are not going to stop working. But I think that the way in which we work is going to change. And I would like to give you some examples. The justice operators developed a function to create rulings that needed to be transcribed. We needed to transcribe what the complaints say, the different types of documents. And there were people who dedicated in a good way to that. Sometimes they were majored in law, and sometimes they didn't. But we know that this is something that has disappeared, because right now it's easier to do a copy paste. And this is a technological change that we have seen. But if we think about all of this, I think the same is going to happen. In many justice systems, and we should not talk about the branches or who is right, we should also talk about the justice system, not only the systems, not only about one system. And technology is saving a lot of time, and they have changed the work that the way that people in the justice system work. And there are different examples when we are trying to search for previous cases, and people took time to go to the different documents to search for some criteria, and they had to invest a lot of time on that. And since we have the use in CD or right now in a web format, the time that we dedicate to that is shorter. But that doesn't mean that we should not dedicate time to that. And I would say that with the reform that was just approved, one of the changes with a great potential or that has an impact in all the areas of law is to understand that the judicial precedents are not just some paragraphs, are the mandatory criteria that are in these rulings. We need to learn to read them, to see where the decisions, what these terms mean, what is mandatory, what was not mandatory. This is a skill that we need to develop, that we need to learn, and we are going to have a lot of work there. For those who want to develop technology systems to make it easier, we are going to have people behind that. We're not going to solve that with artificial intelligence. And I also think that in a different level, I think that we understand law in a very different way compared to what we thought before. We do not understand that as a finite group of rules, because if it was only logic and it was only about finding a rule that was given by the institution, I think that our work as lawyers would not be at stake, because we only require a programmer that helps us to establish these pre-existing rules. But what we know right now is that law is undetermined, is vague, is ambiguous, it needs to be built, and for that we need argumentations. And behind these argumentations, we have values and we have positions where we have to be very honest. And I think that the operators, we have a great challenge and a lot of work. Right now, to build the regulations from which we are solving matters, we need to do more than only looking for specific rules in the code. And also, I think that operators really need to have a better training in law, not only to learn about the laws, but to understand that the facts are not only in the regulations, and we all have great challenges. I think that we are not going to be replaced, but I think that we need to improve our training. Thank you very much to our panelists, Lila, Luis, and Javier. I want to ask a final question, and these are some of the questions that our audience was establishing, and it's how to achieve that these trainings in human rights are internalized and applied. This is the only question that I chose because we are running out of time. I would like to hear you very briefly. I would like to hear your opinions, whoever wants to take the microphone. I can say something very quickly, and I think that Lila has more to say, but I think that one of the ways that has to do with the indicators of result, it's also related to relating the incentives in this career. I think that this is a simple way of having the training and then having a specific and direct consequence, a benefit for the person. But I think it also is related to the follow-up and the decisions of these people, which was to train them, because it means I went to a training and now I know how to use these tools, and then they are reviewing my rulings, and it has nothing to do with what I saw in that training. And right now I learned about an amparo that on forced disappearance, and if the person is not here to ratify in 3 days, then it means something. So these type of things need to be done to measure the real impact of these trainings in our everyday work. And I think that this is on the side of the judiciaries. And I would say that the international organizations on human rights, right now, they are starting to ask the judiciaries, and they are telling them to show them the numbers, the examples that they are complying with the trainings, and that these trainings are effective and have a direct consequence on the rights of people that are using the justice systems. That was my answer. Well, if I may very quickly, and talking about different dimensions, I think that the whole reform on human rights, and there is a speech that had affected it, and it may seem very simple. I think that there are different speeches that have made the use of human rights trivial, and I would say that human rights are positive law, and today an operator of justice cannot not know about human rights. And I think that we need to change this idea. And this comes from the past. If we think that constitutions are just letters of good intentions and that they are not mandatory, we are going to be in trouble. I think that when we start internalizing that these principles that are in the first article of the Constitution are translated into binding regulations for all judicial operators. If we believe that, then everything changes. It's not about just avoiding a ruling or having a ruling that is good and looks pretty. This is translated once again into regulations that we need to establish and incorporate. I am afraid that some of the changes in law are really slow, and they happen because of the changes in the generations. I think that it's not only about the operators that have the greatest responsibility, but also from their work teams. If we talk about the rulings of the court on, for instance, abortion, and we compare them to what was established 10 or 15 years ago, this way or this new way of understanding things is not only result that the justices changed and they think differently, but also because their teams are younger and they have internalized this logic and they know how to operate with these tools. And as a consequence, they are willing to do it. So I think that what we need to bet on is the training. And yes, we need to try to relate them in the proper way with assessment systems. But if we do not bet on training and a slow renovation, we are at risk of looking like making human rights is making justice, understanding justice as the morality that each person has. And sometimes we believe that it's like that. We put human rights as if it was something different than law. So I think that's one of the things that we need to do. Thank you very much to our speakers. Thank you very much, Lila, Luis, and Javier, for giving us all this knowledge. I am being told that we run out of time, so we are going to close this panel on competencies and abilities of the operators. We may continue talking about this topic for hours. This is a very huge topic, and we can relate this topic to a lot of other criminal justice issues in which we can be involved, because it involves all the institutions that are in charge of the administration of justice. And they mentioned the importance as well of the respect that needs to be shown to human rights, as you all mentioned. So in this case, I will give the floor now to our presenter.